Thanks for giving me that opportunity to speak. I've had the other counsel on this matter, and I've had the opportunity of also reading the rules of the committee. And I could see that the committee has a right to deal with to do investigation and also to deal with issues of misconduct, which is what is before you. So we are not saying that by the jurisdiction of this committee, you don't have the power, to deal with this matter. However, what we are saying is that one of the things that my client had raised is the dead on arrival, which the SAN has also mentioned as one of the statements that come from the chair of the committee at a point in time, which was raised on the 5th of March. Sir, please, which was raised on the 5th of March. The rules of the National Assembly is very critical, is important, but it must also be in sync with the Constitution of Nigeria, which dictates in the real sense what fair hearing will mean and what justice, will mean for Nigerians. And that is why we're saying that until when we read that the rule of this house and that constitution, that's when we can say that we have fair hearing and justice in this regard. In this regard, what the petitioner had said is that based on that press briefing, whether it was before Natasha was sent out of the National Assembly or not, gives an impression that the chairman of the committee has a particular understanding of this issue and could be said to be biased, on that issue with due respect, sir. And that is what my client is raising. Now, my client had raised one more point, that in the petition that he had put before you, sir, that the petition had said is going to bring the principal witness, Senator Natasha, as one of the witnesses to speak on this issue. And we are aware that the Senate had made a decision on where she can come and where she cannot come. And so that is why we are saying we are ready to proceed. An oath has been taken. We have our witnesses ready. And the principal witness is Senator Natasha. So we don't also want people to go ahead and think that we deliberately came here, we have been called on serious. We have been called serious, some names here, that we deliberately came here to come and stalemate here. No, that is not our intention. Our intention is that if we are going to proceed, we think the chair of the committee should please step down from this conversation to allow for fairness and justice in accordance with the constitution of this country, because we can give evidence. Premium Times, March 5th, Arise, it was also recorded. We have several documentary evidence to show that at a point in time, the chair had said, dead or an arrival, she has no case to answer, and other things, sir. Thank you very much.
Counsel, thank you very much.
Mr. Suberu, for coming, please. Let me finish. I want to address something. Okay. Please. For coming before us. Learned Counsel, I've heard you. You said because I made a statement in Arise, if I'm correct, therefore I should recluse myself because that shows bias. But let me tell you, and I use the word dead on arrival. That case that came before us, the first petition that came, is not this petition. That petition was signed by distinguished Senator Natasha. Contrary to our rules, you cannot sign your own petition. 2, a petition that came before us did not even have an address. Contrary to our rules, that petition shouldn't have been entertained. Because you are a learned counsel, submit a case, submit your own petition to court, and don't sign it. They will throw it out. Whether you use the word dead on arrival or not, they will throw it out. We are lawyers here, so we understand that. In any case, from the position that I can see you are taking, it means the whole Senate is biased. Because the whole Senate witnessed what happened on the floor. They witnessed it. And so, I don't know what ad hoc committee you're going to now constitute that is not aware of what has been going on. 2, learned respondent has just told us, and I'm sure you have the case file and index number in front of you, that this matter is before a law court. And I will address that. And we'll address that by our rule book, which says Order 47. And I will read on record. Senate should not receive or deliberate on any matter to which actions are pending in any court of law. Senate should not receive or deliberate on any matter to which actions are pending in any court of law. This is our rule book, Senate Standing Orders 2023 as amended. And I'm glad you said you have had the opportunity to read this rule book. Therefore, based on two things. One, the petitioner said he would not speak to his petition because the Senate is biased, or I'm biased, or the committee is biased. Two, the respondent has just told us, and the papers are before you, that this case is before a competent court of law. Therefore, this committee will allow a court of law that will not be biased to handle this matter. Therefore, this matter is closed here at the Senate and is adjourned. Senate died.